Good morning, Your Honor. I'm Angela Beal, the attorney for the minor JB. Another small housekeeping matter. I made all councils aware over the weekend that I serve on a board with Judge Scales, and I wanted to reveal that information to the court. I don't think it affects anything as far as the argument today. All of the council were aware.
It was revealed, and I immediately responded and said there is no problem arguing.
Thank you very much.
May it please the court. At 7 years old, the minor JB was taken from her family, from her sister because she was killed, and from her brother. 2 brothers, in fact. The nature of this case has been sealed, and I just wanted to inquire to the court as to whether that affected anything about the courtroom and presence in the courtroom during argument. I understand that Your Honors have granted a motion to seal, but it was a motion to seal the file, so I'm not familiar with the procedure for whether or not that would include sealing the oral argument proceeding.
Is there any of the lawyers that object from anyone being present during this hearing? I mean, do you wish the courtroom to be sealed for any of the arguments? That's what I'm really asking.
It was my motion, Your Honor, and I think that would be the minor's request. We do have co-counsel here for
Well, but
Baker.
is there any of the lawyers who want this hearing sealed for whatever reason? If so, we'll have to address it. So if there is no lawyer that is requesting that, then I see no reason not to proceed.
We're going to stand muted to defer to the ruling of the court on their motion this matter.
As this is a criminal matter, I'm not sure of the intricacies of sealing a public hearing in a criminal matter, so I would have to defer to the Assistant Attorney General.
And Your Honor, good morning. Melissa Rogashaw on behalf of the Attorney General. At this time, we'll defer to this court.
Okay. I don't think that there's any confidential information that's going to be revealed during this hearing that would in any way prejudice JB or bear harm, so let's proceed.
Thank you.
Thank you.
The removal from her family alone would be the basis of a child requiring therapy. And it's one of the perfect examples for why this is a case about the irreparable harm that's caused when anyone is given access to psychotherapy patient privilege records in violation of 90.503, which specifically says there's no judge decision, there's no balancing test. There's just a privilege, and then there are 3 circumstances under which something would not be privileged. None of those 3 exceptions were noted by the defense in this case. None of them are on the record below. None of them are alleged by defense, nor were there any findings about any of them by the trial judge. What instead happened is that...
Well, I think what the position of opposing counsel is that although there are 3 exceptions to the rule, that there are other exceptions provided in other statutes. For example, section 456, 057, and 395-3025 subsection 4. So my understanding of the argument is that these 2 statutes in and of themselves provide additional exceptions to the rule.
And it's our position, Your Honor, that neither of those 3 chapters are relevant here. 1, because they govern hospital records. 2, because they're the more general discussion of medical/mental health records and not the specific statute 90.503 that talks about therapy records. And 3rd, because the therapy patient privilege that is so carefully not laid out in 90.503 specifically describes all of the records that would be subject to this proceeding. 395, in fact, specifically says it doesn't apply to organizations that provide psychiatric and psychological records. But Citrus Health, the organization that's been subpoenaed here, is solely an organization focused on the clinical, psychological, and psychiatric health of children and giving those services. It excludes any consideration by this court or the trial court of 395, 394, 397, or 456. And specifically, the trial court would basically be eviscerating the purpose of 90.503 if it said that these other more general statutes apply. When 90.503 talks about the records of what happens when just a therapist and a person, in this case a child, are sitting in a room alone, discerning the revelation of fears, specific information, emotional information, of course. It's not a privilege that just applies to children. It's not a privilege that just applies in the abuse and neglect proceeding. It applies to all authorities. That anyone who walks into a therapist should have the reliability and predictability that that information won't be revealed. There are other statutes where trial courts are certainly permitted and invited to balance considerations. But this court has talked about the importance of just the act of breaking that therapeutic privilege being significant in Florida Department of Transportation versus Tropical Transport in 2017, just this third DCA.
Well, and this court, en banc, already has determined in Miglietti
Yes.
that there is no balancing test. So
That's-
we don't have to address whether or not we should apply the balancing test, although I'm not even sure if we applied the balancing test under the facts of this case that it would lead to the disclosure of these records. But it's been definitively determined by this court, and my understanding is that, once we've made that determination, trial court's bound by it unless we rule otherwise.
And I think there'll be more discussion about Miglietti and my joint counsel. But of course, we agree with your honors, and the reason that this is as a writ, an extreme remedy that we're looking for the court is actually the presence of JB through myself and all in this court. She's not a party to the criminal court proceeding. She's not a listed witness.
So neither side has listed her as a witness.
Not so far. The state has stated that they would not, the defense has not made a determination about that.
My understanding is that defense really wanted to look at these records to then determine whether or not she would be competent as a witness, and then to determine also whether she might have some relevant information that they could use in defense of their client.
That's certainly what was represented, and it's certainly not is what allowed under the law. The defense can't raise the competency of a witness, as they pointed out in the footnote on page 7 of their brief. They can't raise the competency of a witness. She would. So if the minor were, for example, put on a deposition list or received a subpoena for deposition, then she could, if it was relevant, raise her competence. But competence is also
The trial court's ruling was based upon the trial court's attempt to try to minimize any potential damage or harm to the child, hoping that once the records were examined, that this would either, alleviate the question of whether or not to depose her to see if she had relevant information, or give further information as to whether a deposition would irreparably harm this child.
And of course, the Florida legislature doesn't allow that extra effort by the trial court. I understand the court's stated intent, and I understand I'm over my time, so if I could continue to finish my answer. The therapy patient privilege doesn't allow the court to make that representation. And here, I'm not sure that representation would have worked, because the defense has already announced that they just want a general understanding of everything about this child. And then they want to understand confidentiality. They've received some records about her history. They've received a DCF file. They've received a videotape of her that was taken less than 48 hours after she was removed from her family. And they have not found any concerns about her competence just from that information. So it seems unlikely that anybody would in reviewing further evidence. More importantly, competence is temporal. Competence is something that a court decides at the time that a person may or may not testify or be deposed, and about the issue that a person may or may not be deposed.
Well, competency is, you're not going to look at something 7 years earlier to determine competency now if you're going to depose somebody.
And that's,
It seemed more to me that it was to determine whether she may have any relevant information. I mean, this is a death penalty case, and you want to make sure that you've explored every avenue, make sure that if anyone has any relevant information, you tapped into it.
which is exactly what a deposition is for.
Thank you very much.
Good morning, may it please the court, Thomasina Moore on behalf of the Guardian Alignment Program. The program concurs with Ms. Vito's argument that this is a legally insufficient motion and would ask the court to grant the writ on this basis alone. However, should this court consider the privilege issues, then under even the most permissive standard of cases that have been addressed the issue from Florida's district court, this would still be a legally insufficient motion because there's no reasonable probability that any exculpatory evidence would be found by going through these documents, or that even any information likely to lead to the discovery of relevant information would be found. And therefore, the order should still be quashed. If I may go back to Justice Rothenberg's question regarding Famiglietti, I do want to clarify one point. Famiglietti was a plurality opinion. The Judge Cope's opinion had 5 judges join, but that was an 11-judge court at the time. So it's not truly a majority opinion, nor binding. Further than that, Judge Cope's opinion did not address the issue of constitutionality, and since that has been raised by the briefs, we want to also discuss the Pender Court and Catlin Court and the arguments raised there, which, as I said, would be the more permissive of the analyses. So under those cases,
But hasn't this court already made a determination that, or at least has concluded that the Pender case was wrongly decided, and hasn't the Fifth already concurred with the Third in finding that it was wrongly decided? So why would we even look at Pender?
the Fifth has decided that, again, the district court opinion from Miglietti here does not have a true majority. So we would ask that the court follow the majority reason, plurality, the opinion, reasoning,
I guess very confusing.
adopt that language which says, no, it's an absolute privilege and cannot be pierced. To the extent that the court finds, however, that the privilege has to give way to any constitutional considerations raised by the defense, then you can go back and look at Pender or Catlin, because Judge Cope's opinion in Miglietti specifically did not consider the constitutional considerations. They said here they weren't raised, we're not considering them, whereas in Catlin they did. Catlin went back to the United States Supreme Court in Pennsylvania versus Ritchie, which did have not what I would call a balancing test, because in my understanding of qualified privileges and balancing tests, that's more of the judge looking at the facts of a particular case, and not a court saying, okay, we have a constitutional consideration at issue. So I'm not really arguing either absolute or qualified privilege by doing that. I'm saying, looking at balancing the 14th Amendment due process right and this child's privacy rights, where do we strike that balance? And in Pennsylvania versus Ritchie, which was a case involving a child's records, they adopted a test very similar to Catlin, which we mentioned in our brief, which, as I'm saying, the most permissive test, and they're still not going to get there, because under the first step in Catlin, you have to show a reasonable probability of some relevance, some exculpatory material. There's nothing in what they pled which would support that argument. There's no competency as
Defense counsel really had argued that the records might potentially be relevant, not that there was a reasonable probability that they would be relevant, and that the trial court made finding that the disclosure could potentially be relevant. The records would potentially safeguard the child. That was the language used not only by counsel but also by the trial court of this potential relevancy and potential safeguarding, and might lead to something. And I think even one counsel argued that we'll just look at these records and see where it goes from there, where it takes us.
Exactly, Your Honor. Those were, I will quote from the transcript of what they wanted to do. And as you previously established, competency is temporal, so it can't be a competency issue. And what it really has to be is, given that she's non-witness, who they've had a videotape and have been able to see what she would call contemporaneously 6 or 7 years ago, there was no any real argument that it's reasonably probable. Again, I think reasonably probable would be too permissive of a standard. I think for Miglietti, you could say that they have enough opinion, enough judges in that opinion to say it has to be somewhat higher, be a likelihood. But let's use that lowest standard. And given what they argued that they might, there's a possibility, that's never going to get past Catlin to even trigger what would be an in-camera review. Here we didn't have that threshold showing. We had no in-camera review of the documents. They were just ordered to be released wholesale without anybody else looking at them to see, is there anything relevant in there? And then the third point would be, given whatever we found that was relevant out of these 7,000 plus pages, do you still get to introduce that evidence? How do you get to use that evidence? So there's 3 steps. They don't get to the first one. I'm not sure anyone.
Yeah, you have exceeded.
I apologize, and I'll say my 1 minute for rebuttal.
Thank you.
Thank you.
Good morning. May it please the court, Melissa Robichaud on behalf of the state of Florida. Your Honor, the state echoes the same sentiments as the guardian ad litem individual in this case, and only emphasizes that the larger and broader application is what is the state's concern at this point, which is that this court has previously held that just because you are an eyewitness or potential eyewitness does not mean that you are then privy to confidential records. And under Miglietti's specific language. Just the 4 reasons why the former DOE actually said the proffer by the defense was not specific enough. It was because it did not establish the original probability records relevant to the defense's theory. That was one, as Your Honor had stated. It was conclusory in nature. It said little beyond express desire just to view the records in question. And it had a general request to conduct a fishing expedition through the victim's confidential records. Now, this isn't even a victim. This is a child witness. I believe that the state explained its reasons for why it did not list her initially into discovery, but nevertheless, the defense knew about this witness, had a CAC interview explaining what she saw, what she didn't see at the time, and that was more contemporaneous to what they're now looking for now. So at this point, if this court has no further questions of the state, I will reserve my time for rebuttal and ask that this court respectfully quash the trial. Thank you. Thank you.
Good morning, and may it please the court. My name is Philip Reisenstein. On behalf of the Office of Regional Counsel, I'm appearing for Carmen Barahona, the respondent in this matter. I want to, I guess, address some of the questions that have been raised, and I think that the court is also making some indications that you may have concerns about. But I would, so therefore, I would first start with what Judge Rothenberg, you were talking about in the phrasing of the language during the application for this and the potentiality and the possibility.
And in the trial court's order, because that's what's really before us. I mean, when you have the trial court making findings, you know, that this potentially, let's see what the court says.
So I have the order in front of me.
This is eyewitness to many, if not all, of the counts in the indictment. Court believes that the state and defense need to review these records to adequately prepare for trial. The need for the requested information outweighs the possible harm of disclosure. The court was made aware of the fragility of the child, and the disclosure of the potentially relevant records will potentially safeguard the child from the trauma of a competency hearing, deposition, and testifying. And prohibiting the disclosure would actually harm the child because the parties would move to depose, JV, and or request a competency hearing.
So I don't view, and I think I don't think the court should be misled by what the trial court is saying and using the words potentiality, because those aren't undermining the order in this case. The court makes specific findings here that this is in the best interest of the child. The state of Florida.
But isn't that a determination that the child or the child's guardian or the child's lawyer needs to make? I mean, for example, if you subpoenaed the child to testify at a deposition, and counsel says, well, we think that this could really lead to irreparable harm by having the child relive all of this in a deposition. What if we offer you her psychological records, and you go through those first to see whether or not you really even need to depose her, or offered you anything in return for something that you could examine to make that determination as opposed to an actual deposition? Isn't that a determination or a decision they need to make as opposed to the trial court when you're talking about privileged information? It's not whether it's going to harm the child, but whether or not there's a sufficient showing to pierce that privilege.
So I don't disagree with your analysis, but I was only saying that the trial court included that in her order to show that the trial court had considered everything in this case. To specifically answer what you're saying, the trial court was told during the arguments before it in the record and the transcript that was supplemented recently over the weekend on pages 13, 14, 15, and 16 that this child was an eyewitness in a first-degree murder case, that this child was a witness to phase 1 and phase 2
And depose her.
and evidence in this
They
case.
move to depose her and see where it goes from there. And
Well, I think
that
this.
doesn't mean you just get the psychological records,
Well, I think in a sense this is a be careful what you ask for, because you may get it on
But
behalf
you
of
get it
the
anyway. You
people.
get those medical records, take a look at it, and decide you want to depose the child, and you're going to be right at the same point. Only difference will be is you'll have all of these confidential, privileged records.
Okay, so I don't disagree with you that deposition in this matter is something that the defense should do and is something that is available, but I would like to concentrate my argument on why this privilege, though, still should yield. in this regard, okay? Because I'm not disagreeing with what you're saying as one way to proceed in this matter. That clearly is correct. So the decision in Fagliametti starts off with and says, the question presented is whether the defendant in a criminal case can invade the victim's privileged communications with her psychotherapist if the defendant can establish a reasonable probability. Now, part of what the argument is with petitioners is that the defense can't establish a reasonable probability, and they hang on the fact that counsel during this argument was using words like, well, we want to see what's in there. My response to that, first of all, is I don't know how attorneys can say there are things in that record that clearly establish what we need when they haven't seen it. So it's kind of a catch-22. But to take it a step further, the state of Florida said, we're not listing this witness because this child is not competent. So that was the issue before the court. And the defense said, well, this child has been interviewed by a therapist, and there are records that would establish whether or not this child is competent. So that's the specific reason for what they're seeking. So now we come down to under 9503, can it be pierced?
If they go down that road at some point where they're going to rely on those records, then they're going to have to reveal them. But simply saying that these records may show she's not competent is no evidence before the court if the court is going to have to determine competency on its own based upon whatever was presented to the court at the time if it's relevant.
So just to make sure I
You can't just say
understand.
we're relying on the psychological records without revealing them. So if they, at some point, if you move to depose the witness, and the state comes in and says, we object because she's not competent to testify, then they're going to have to present evidence to that fact. If they don't rely on the psychological reports on whether or not she's competent at this time, then you don't get to them. If they do rely on them, then obviously they would be subject to disclosure.
Well, the point, though, that makes these records particularly relevant is it occurred around the time of the incident. So
But
anything
7 years before any deposition and any determination of her competency now.
okay.
I mean,
So-
why would those records from 7 years ago be relevant at all as to her competency right now to be deposed?
Okay, so I understand what you're saying is that as counsel has argued, competency is a fluid concept and what occurred back then may not necessarily.
The child was like 6 or 7 or 5 or 6 or something at the time.
I think 7, sorry,
Yeah,
yes,
she's much older now.
I agree with that. So the answer to that is that there is a expert speaking to this child at that time when these things are occurring. And again, while the records have issue regarding the child's competency at that time, there is also a discussion of, and I have to use this word because we haven't seen them, so how do I not say it, of perhaps what may have occurred that makes this relevant as to phase 1 and phase 2. And if you put us in a box and say, you can't get the records unless you tell us what's in there is relevant and we haven't seen the records, then I need Mr. Jacobs to come up here and help me because I don't have an answer for that. I mean, that's it. I guess then I have to concede at that point because I can't manufacture facts. So I think it's kind of a conundrum here that we don't have to be that
In a
strict.
deposition, couldn't you, if you're able to depose her, ask her those questions, the kind of questions that could reveal any information that would not be confidential, privileged information between her and her psychotherapist?
Yeah, I don't disagree with that. And again, if the position of this court is the cart is before the horse, we're just seeking this too quickly, then I certainly understand your argument, but I do think that we do. So then,
If we were to grant this petition, this would not in any way preclude you from raising the issue that becomes relevant at some point in the future. But to request on this, well, maybe there'll be something in there we can use, grounds, just doesn't get you there.
well, we're always going to be in that position, though, because we're never going to know what's in the records, even if we speak to the child, and she is either an acceptable witness for us, or there are portions of the evidence that we like, and portions of the evidence that the state like. We're still going to be in the position of what was occurring with this child, talking to somebody at a time period very relevant to the issues in this case. And that's why I would like this court to consider the argument, as you raised, Judge, about, and I want to draw a line, 456057 being an operative part of the Florida legislature that does create exceptions to 9503. And the Sun case stands for that proposition.
Yeah, doesn't section 456057, it actually contains similar language in the other statute, which is 395-30254, but says that in any civil or criminal action unless otherwise prohibited by law upon the issuance of a subpoena for the court of competent jurisdiction, proper notice to the patient or the patient's legal representative by parties to these such records. Wouldn't this otherwise be prohibited by law, and specifically the law in 90, whatever that is?
9503.
Yes.
Yes, I was anticipating this question.
Of course.
It is what they have raised, and my notes to myself are, where is the case law or anything that says, as otherwise precluded by law means 9503? And my answer is, I don't see it. And I would cite to you.
Otherwise prohibited by
By
law,
law.
so you gotta list every law that it could be prohibited
See,
by.
I honestly don't know what they're talking about, but if you read Judge Serrando's dissent in Family Getty, which I think is very well reasoned and talks about the fact that this is a qualified privilege, and you read the 4th District's decision, surprisingly the 4th District, in State versus Son, which says, and I'm just quoting a portion of it, Section 456057 represents a legislative attempt to balance a patient's privacy rights against legitimate access to medical information. Then I think we're back to then your question, what does otherwise prohibited by law mean? And I don't read it to believe 9503.
Well, if you look at the language of 9503, it says a patient has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications or records made for the purpose of diagnosis or treatment of a patient's mental or emotional condition between the patient and the psychotherapist or persons who are participating in the diagnosis or treatment under the direction of a psychotherapist. So that is the law that prohibits a court from ordering the disclosure to be otherwise prohibited by law, and then you go to subsection 4 that gives the 3 exceptions.
And I'm in full agreement, by the way, that the 3 exceptions listed aren't the ones that are here. There's no doubt about that. But I don't read that. So then, though, you're running into this, you're bumping up and you're running into this issue. Is 9503 a qualified privilege, which is balanced by 456057, or is it just exactly what it says it is, and no more and no less? And I think that the way the case law is reading is it is more. It's not less. And Judge Serrando listed a hypothetical, which I would say to this court as well. If situations were somewhat reversed and there was a defense witness that was an alibi to a first-degree murder, and the state found out that they'd been treated for in a mental institution and previously been declared incompetent, would we say that the state couldn't get those records?
Well, it would depend on whether he places his mental status at issue.
Well,
if he places it at issue, then of course they're going to get to it. But if he never places his mental status at issue, they're not going to get to it.
Well, if it was an alibi witness, the defense would just say, we've got a great alibi witness, and the state would say, wait a second, he's been declared incompetent in the past. We want to see what his records say. They're the ones who want to impeach the witness. This is, in a sense, what we're talking about here, not just the ability to depose a child, but to also perhaps, and again, I have to use that word because we don't know what's in there, see what's impeachment evidence in those records.
I'm just saying that if the state's position was that he was incompetent to testify as a witness, that they would get access to his psychological
They
records.
won't impeach him. They say he can't be a good alibi witness. He's on medicine and been declared schizophrenic. And Judge Serrando used the issue of if a witness had been, and the notes of the therapist was if the witness is taking its medicine.
Couldn't they get that information without going to the psychological records?
I don't think so, not if it's the witness is taking its medicine and so therefore is competent. When it doesn't take his medicine, is not in the medical records. I mean, the point I'm trying to make is
They could call the doctor and they could ask the doctor those questions. Have you treated this patient? Is he on medication? What medication is he on? What happens when he doesn't take his medication? You don't have to look at the records.
well, we can call the doctors here, but we're going to get to the point. Was this child competent at the time? What did the child say about what occurred? Because that becomes relevant in our case.
It's really, you want to know what the child said about the events.
In a capital murder case where our
Of
clients
course.
charge
I
me
mean,
that,
it's
how
not
can I
a
say no to you? Of course.
You know,
But I don't call it a fishing expedition, by the way. I think it's, and I don't think Judge Safety is designed to order to be a fishing expedition. It's narrow, it's tailored, it's specific on the facts, and I don't think it meets the level of certiorari in this matter.
Just so I'm clear.
Yes, Judge.
Judge Safety's order to me was kind of a wane. And was
I'm
kind
sorry,
of a
what?
wane.
Oh, okay.
Wane.
Sure.
When I read the order. I thought it was a very good order, but it was a wane order. And so your position is that 90.503, even though it has 3 specific exceptions, actually there are some other exceptions that could be intertwined to put in there.
Yes.
Such as weighing.
Yes, and I would point you again to Judge Toronto's
Right.
dissent in Family Getty, and the fact that I don't see 456057 discussed in the Family Getty
Right, it's not.
decision, but it is discussed in Sun, and it is discussed in cases that say it represents an exception, but we do come back to what Judge Rothenberg has said, which is then otherwise prohibited by law. They cited that. I'm aware of it, but I don't find case law that says that means a privilege.
I got you.
Can I just ask one
Sure.
question? Would you address Jaffe, which is the U.S. Supreme Court case that found that you don't weigh, that there is no balancing test?
I may owe him something here, but I'm going to cite Judge Toronto again. And yes, and I was prepared for this. In his dissent, he writes that, well, the majority of Family Getty suggests that the Jaffe language isn't clear. What he writes is it does not stop. It goes on to say, because this is the first case in which we have recognized the psychotherapist privilege, it is neither necessary nor feasible to delineate the full contours in a way that would govern all conceivable future questions. We do not, and then he cites to the Upjohn case, the Supreme Court, we do not doubt that there are situations in which the privilege must give way. So those cases, while, as Judge Toronto said,
In his dissent,
apparently do say support would be the position of this court reversing the order. They kind of also say this is a new area, and we do not doubt that there aren't circumstances in the future which would cause this privilege to be pierced. We think we're right within that wheelhouse of that language in Jaffe and in Upjohn, where we're 10 years later and we've now confronted this very unique situation with a child witness in a first-degree murder case.
thank you.
Okay, thank you very
Thank you
much.
very much.
Because the court respondents are asking this court to act as another member of the legislature, and it simply can't. Not that the trial court did. It wrote an exception into 90.503, the more specific statute that is certainly allowable for reference in the more general statute of 465 by creating an exception because this is either a first-degree murder case or a death penalty case or a case with a child witness. None of them are there. The legislature had the ability to write those exceptions, and they did not. In fact, Jaffe says, making the promise of confidentiality contingent upon a trial judge's later evaluation of the relative importance of a patient's interest in privacy and the evidentiary need for disclosure would eviscerate the effectiveness of the privilege. And then again, Judge Cope cited that in his plurality decision. There would be no therapy patient privilege if any trial judge could just weigh some factors and poke a hole in it. It's not justified here.
Please, the court very quickly. Although opposing counsel asked this court to look at State versus Sun, he makes no argument regarding how his request actually meets that standard, which is what I discussed earlier. They have to have that threshold, which has not been shown or demonstrated here. The guardian ad litem is appointed specifically to represent the best interest of the child here, and we ask that the court grant the writ of certiorari, quash this order, and send it back to the trial court to let this process play itself out and let us do our job. Thank you.
Thank you.
Your Honor, the state will rest on its argument.
Thank you very much.